Ladies and gentlemen, how do?
Labour dropped its appeal against a High Court ruling that said the Crime and Policing Bill, which was brought in through the back door using secondary legislation by the Conservative government, was illegal.
We just found out that the government won't be appealing our legal challenge against anti-protest powers that were created unlawfully. That means that finally, these laws that gave the police almost unlimited powers to clamp down on protests for supposedly causing more than minor disruption and criminalised hundreds of people in the process are officially gone. We started this case 2 years ago, in 2023, when former Home Secretary Suella Braverman changed the legal definition of when police could place restrictions on protests from serious disruption to mean more than minor. We won this case in court twice, first against the Conservative government in 2024 and then again against Labour this year. Labour should never have wasted taxpayers' money appealing this case, especially since Yvette Cooper herself opposed these laws as they were going through Parliament.
What it is doing is giving the police the power to prevent any and every campaign group protesting outside a local library or swimming pool that is about to be closed because it may be a little bit more than minor. The government is simply making it possible to go after peaceful protesters and passers-by instead, even though that is not the British tradition.
We're glad the government has finally accepted defeat, but this doesn't address the hundreds of protesters who have wrongly been arrested under this legislation. The government should now commit to reviewing all arrests made under these unlawful powers.
This is the second victory for the civil liberties group, Liberty, but the elephant in the room here, which Labour are trying to sweep under the carpet, is why they were appealing the High Court decision made on the 28th of August 2024. And not only were they appealing it, but Labour were actively seeking to strengthen this already very draconian bill by trying to make wearing a mask at a protest against the law.
Why are you guys wearing masks? Like, if you guys are, proud of what you're standing for, how come so many people are hiding their faces?
The Crime and Policing Bill is trying to ban people like me from wearing masks at protests.
Crime and Policing Bill continues the crackdown on peaceful protest, including by giving police the power to ban concealing your face at a protest. The government wants to characterise everyone who covers their face at a protest as potentially violent criminals. But we know from our work that many people need to wear face coverings at protests for perfectly legitimate reasons. Whether it's concerns about racist surveillance, you're an immunocompromised person protecting your health, or you're simply someone practising your faith.
Facial coverings, in our case, are not a threat to public order, but rather an essential shield protecting us from foreign repression. We still wear masks at protests because Chinese and Hong Kong authorities still trying to hunt us down.
I wear face coverings at protests to protect my identity from a state that is hell-bent on trying to repress student and wider community activism for Palestine.
For many people, wearing face coverings makes protest impossible. Treating protesters who wear face coverings as criminals gives police more power to arrest more people, further intimidating people into giving up their right to protest. Whether you wear a face covering or not, this bill impacts us all. It's another attack on our freedom of expression and our basic human rights. Every single one of us should have the right to participate safely in protest without being criminalised.
When Labour were in opposition, they made a big song and dance about how draconian Suella Braverman's Crime and Policing Bill was, with many fine speeches by the Shadow Home Secretary, Yvette Cooper.
And this makes it harder for law-abiding peaceful campaigners who want to work with the police to organise a limited protest, something we should all want people to do, all for the sake of the Home Secretary getting a few more headlines. She says she wants to defend free speech and our pluralist free society very robustly indeed, just only if it is speech that she agrees with and only if it isn't too noisy. And once again, instead of focusing on the damaging disruption, where all of us believe it should be stopped and where we want to see the government working with the police to sort things out, instead the government is simply making it possible to go after peaceful protesters and passers-by instead, even though that is not the British tradition. They brought a statutory instrument before us today claiming that it is to clarify, but instead it makes the law even more confusing. They failed to bring it in through the normal parliamentary legislative processes, legislation that can be scrutinised and amended, and heaven knows we've had enough primary legislation where they've had the opportunity to do so. It redefines serious disruption to instead mean everything which may be more than minor. Which may? Does the Home Secretary really think anything which may, only may, create more than minor noise, for example, should be able to be banned by the police? Once again, this is not about the seriously disruptive Just Stop Oil protests, which are rightly already against the law. Instead, what it is doing is giving the police the power to prevent any and every campaign group protesting outside a local library or swimming pool that is about to be closed, because it may be a little bit more than minor.
The court's judgment shows that nobody is above the law. The way in which the former Home Secretary introduced these regulations was unconstitutional and undemocratic, and the court today has said that it was also unlawful.
Now, the new Labour government are appealing the judgment. This is a concerning disregard for the rule of law and goes against recent statements by the government that they would not abuse the use of secondary legislation.
So why did they not just drop this appeal, which had originally been brought by the Conservatives?
On July 4th, 2024, the UK electorate voted Keir Starmer's Labour into power with a landslide majority. The new Labour government then had to decide whether to continue the former government's appeal or defend democracy and the rule of law by dropping the appeal and scrapping these unlawful powers. You might think the decision was a no-brainer. After all, Labour had opposed it in opposition.
A certain Labour supporting YouTuber, one Mr. Phil Morehouse of a very certain bias, claims that Labour were too busy and this had slipped through the cracks. Seriously, how stupid do you think people are, Phil? Riddle me this: if this had, as you inferred, slipped through the cracks, then why were Labour looking to strengthen the bill by making it illegal to wear masks, and why not just drop the appeal? It was the Tories that brought the appeal in the first place, and Labour could have done a nice little victory dance.